The Obama administration drops any attempt to prosecute those responsible for Bush-era torture. Will any U.S. personnel ever face criminal charges for the abuse of prisoners? You're watching Inside Story Americas from Washington. Hello, I'm Shihab Ratansi. They're interrogation techniques widely considered to constitute torture and an aspect of President George W. Bush's so-called war on terror that was heavily criticized, not least by the man who replaced him.
What I've said, and I will repeat, is that waterboarding violates our ideals and our values. I do believe that it is torture. I don't think that's just my opinion. That's the opinion of many who've examined the topic.
Well, now, despite a vow to restore America's moral standing in the world, President Barack Obama's administration has ended its pursuit of U.S. personnel who abused prisoners in the aftermath of the 9/11 attacks. The U.S. Attorney General, Eric Holder, made the announcement last week, saying that the admissible evidence would not be sufficient to obtain a conviction beyond a reasonable doubt. An investigation that initially looked at 101 cases, in the end examined just 2. That of Gul Rahman, who died in a secret CIA prison in Afghanistan in 2002, and Marandel al-jamadi, who died in CIA custody at Iraq's notorious Abu Ghraib prison in 2003. The decision not to prosecute even these cases has dismayed Obama's supporters, who had hoped that his presidency would mark a clear break from his predecessors. And while CIA operatives and those who gave them their orders apparently now enjoy immunity from torture charges, one man is to face a criminal trial. John C. Kiriakou, the intelligence officer who confirmed to journalists that torture had taken place. So, how will this affect America's standing in the world? And without accountability, can we be sure that such abuses have stopped? With me to discuss this is Robert Grenier, a former director of the CIA's Counterterrorism Center. Next to him, Christine Husky, director of the anti-torture program at Physicians for Human Rights. And from New York, international human rights expert Scott Horton, who's also contributing editor of Harper's Magazine. Professor Horton, first of all, actually you commented in an article last week about the timing of the Attorney General's announcement. Do you think the administration was trying to bury this?
I think there's just no doubt about it. I mean, whenever a press release comes out this way, just before the Labor Day weekend, this is the absolute low point in the news reporting cycle in Washington. It was a story that was unlikely to get much press attention or play in the United States. And in fact, I think that's generally what's happened.
All right, so quickly remind us what happened to Manadel al-Jamadi and Gul Rahman.
Well, al-Jamadi was seized by Navy SEALs and taken to Abu Ghraib prison in Iraq, where he was being interrogated by a CIA agent, Mark Swainer, and he was held in a stress position that's been historically called the destripado. It involves suspending the person who's being questioned. It was, in fact, a forte of the Spanish Inquisition for many centuries, and he died in that position. And was packed in ice. So photographs of al-Jamadi are absolutely iconic. They're one of the few photos you see over and over again coming out of the Abu Ghraib scandal. The second case, Gulman, was suspected of terrorist activities in Afghanistan. No question about the fact that he was a Taliban. He was held in the Salt Pit, which is a CIA detention facility located in an abandoned brick factory north of Kabul. And he was held in an arrangement that's known as the cold cell. He was stripped and placed in a cell where temperatures at night plunged down to about 2 degrees Celsius, just above freezing, and he expired in those conditions. So we have in these two cases deaths that appear to be unequivocally tied to the use of specific torture techniques.
Professor Husky, though, let's be clear about the investigation that's just been concluded there. This wasn't about whether torture took place. It was about whether anyone went beyond the official guidelines as to how much torture could take place.
That's correct. And if I might just add to the al-jamadi case, two very important factors, which is that he asked for medical assistance when he was brought in, which he wasn't provided. And it was actually ruled by U.S. officials after his death that it was a homicide. Those are two very important factors when we talk about now where the investigation is going or is not going. So you're absolutely right. The question was not whether torture occurred or interrogations occurred, but whether they occurred beyond what was allowed by OLC legal counsel memos.
And there have been several, quite exhaustive investigations. These are the only two cases that conform to perhaps some sort of overstepping the boundaries that had been set in Washington.
Well, I mean, you have two dead bodies, one of which has already been ruled a homicide. That there cannot be a further investigation into that, or that there's not enough evidence, is frankly beyond me.
Well, that was what the Attorney General said. The admissible evidence would not be sufficient to obtain and sustain a conviction beyond a reasonable doubt. Robert Grenier, what do you make of that judgment?
Well, first of all, I think the facts and the cases that have been provided here are extremely misleading in that whatever was done, the individuals who were involved were not operating under OLC guidelines. So neither of these two individuals, neither of these two detainees, this fellow Jamadi or Gul Rahman in Afghanistan, were part of a CIA interrogation program, so-called. So I'm not trying to.
Yeah, that's very interesting. Yep.
So so this is really quite different. It was people who were involved in that specific program who were bound by judgments that were made by OLC about what was permissible and not permissible. So whatever may have been done to these two individuals, or any misconduct which took place, these people were essentially operating on their own.
But in fact, the OLC memos are more permissive than what would have been the standards for where al-jamadi was, which is DOD.
The OLC, Office of Legal Counsel.
Sorry,
DOD,
Department of Defense.
Right.
And al-jamadi would have been under military custody.
Exactly.
No one at Abu Ghraib was under CIA custody.
Which has stricter standards than the OLC memo. So.
Well, in theory, at least, I guess, military.
Well, in reality.
Yeah. Well.
So what do you make then of the
military
judgment?
personnel are not supposed to go beyond the Army Field Manual.
So. Right, exactly. So what do you make then of the judgment of the Attorney General that there wasn't sufficient evidence to obtain a conviction beyond a reasonable doubt, Robert?
That is a judgment that prosecutors make. Most prosecutors that I'm familiar with, if they can make a case and make it stick and get a conviction, they're all for it.
Are you confident that this investigation was handled thoroughly, do you think, from what we know?
Well, again, I have no reason to believe otherwise. I mean, to think otherwise, then you would have to have had a huge conspiracy, because this is not the first time that these cases were looked at. These same cases, along with many others, were looked at during the Bush administration. And in both cases, they were looked at not by either Bush or Obama appointees. These cases were looked at by professional prosecutors. So,
Professor Horton, are you convinced that this was investigated thoroughly?
Well, I don't think you have to believe in conspiracy theories to have questions about this. I think first, just note that the Attorney General stressed the question of admissible evidence. And of course, one of the fundamental issues relating to this investigation was whether classified information, and virtually everything surrounding these two cases was classified, would be declassified so it could be used, so that you could hasten a decision that there was no admissible evidence by failing to declassify the evidence that existed and allow it to be used. That's one consideration. But another major one is that any prosecution would inevitably wind up bringing into question the application and interpretation of the OLC memos that have been mentioned so frequently. And there's simply no way you could do that without immensely embarrassing the Justice Department, because I think one of the fundamental questions here was whether or not these memos actually constituted a license to kill. And I think it's easy to understand how federal prosecutors doing the initial investigation and the Attorney General would conclude that it's not in the institutional interests of the Department of Justice for all of this to be vetted at a trial. That, to me, is the more compelling justification for the decision.
In the absence, though, of complete transparency in this investigation, then a lot relies on John Durham himself, the man who was investigating this. What do we know about him?
Well, I would say we know you're talking about the interrogators here.
No, I mean,
CIA,
actually,
or you were talking about
the Attorney General picked John Durham to lead the investigation.
Oh, I'm
maybe
sorry.
my pronunciation wasn't
we
correct.
know that he's a career, yes, he's a career prosecutor from Connecticut. He's also a registered Republican. He was originally selected by Michael Mukasey to handle this matter. He's someone whose own political sympathies have never been in question. He is a friend of the Bush administration and a supporter of the Bush administration, but there's no reason to question his skills as a prosecutor beyond that. But note that this determination rested on an exercise of prosecutorial discretion, and that discretion can include, amongst other things, the institutional interests of the Justice Department and of the United States. And I think here we are focusing the prosecutorial effort on people pretty close to the bottom, the interrogators. The prior prosecutions that occurred involved grunts, basically, low-level enlisted personnel. And the real question here goes to the introduction of policies at the highest levels of the executive branch. And it's very, very difficult to proceed with these investigations or to proceed with any prosecution without addressing that question. And that's a direction in which the Justice Department was from the outset unwilling to move.
Robert Grenier, would you accept that, to prosecute some grunts, as Professor Horton put it? I mean, inevitably, though, the question of the chain of command and command responsibility would have to come up, and that would mean a lot of people in Washington would be very uncomfortable. Does that necessarily mean?
Well, if you're going to do the former, then surely you should do the latter. You should be willing to go up the chain of command. But it seems to me that the analysis about the political interests of the Department of Justice really kind of breaks down here. It seemed to me that when Eric Holder made the decision in the first place that he was going to reopen all these formerly pursued and then closed investigations, that struck me as being highly political. It seemed to me that this administration wanted to make a clear distinction between its approach and the approach of the former administration. However, the people whose cases were then being reopened were, in fact, professional prosecutors of the Department of Justice. Who else would that have embarrassed but the Department of Justice? And in fact, I'm frankly surprised that we haven't read stories about the reaction of those prosecutors, because it seems to me that would have been a tremendous insult to them. So it seems to me that if the concern on the part of Eric Holder were institutional embarrassment of the Department of Justice, he already crossed that threshold when he decided to relaunch these investigations.
But wasn't he
in the first
required
place.
to? I mean, there have been several exhaustive reports, Professor Husky. Shouldn't mandatory investigations under international law be taking place? Is it a political decision?
I was just going to say, I mean, I think that it's certainly, it'd be one thing if they just decided not to investigate at all, but obviously under all the treaties that we've signed, the human rights treaties, we have an obligation not only to not violate, that is to not, violate somebody's human rights, but we have an obligation to investigate and prosecute. So to go forward with the investigation at least is a step in the right direction. I don't know if it's if that was a political move. That was just our obligation. That was our international obligation under international law, and something that should have been done anyways. Certainly, as a country that believes in the rule of law.
We're kind of comparing apples and oranges here a bit, in that the two cases that we've cited here really didn't involve the OLC memos at all. Now, I agree that if you're going to argue against the use of waterboarding and other techniques that are referred to as torture, then you really need to go to the source. And that if you were going to pursue a serious program of investigations leading potentially to prosecutions, you don't just go after the grunts, as you say. You actually go after the people who signed off on the policy.
And the Attorney General is quite clear. This inquiry does not resolve the broader questions regarding the propriety of the examined conduct and so forth. But I mean, given there is so much evidence as to how these decisions were made to torture people, whether and indeed, and that may have led even to beyond what they had expected, don't those questions need to be answered then?
Well, I think there have been, again, a number of cases where CIA interrogators exceeded the ground rules that had been set. And so it's one thing is there are institutional issues involved when you're engaged in activities that are actually sanctioned by your superiors and ultimately by the Department of Justice. These limited number of cases, they actually exceeded those, and those were looked at by prosecutors for potential prosecution, and apparently they didn't find cases there. However, that is not to say that no one involved in abusive interrogations has been prosecuted. In fact, such prosecutions have taken place. I know of one at least in North Carolina.
A contractor. There has been no accountability of any U.S. official. And I mean, it's just, you know, if you think about it, it really is amazing. You have, you know, especially in the case of al-jamadi, who was his death was ruled a homicide by U.S. officials. How can there not be, you know, enough evidence? And I mean, granted, this would go to the jury, so it's not up to Holder to decide if there's going to be a conviction. It's whether or not there's enough evidence to bring an indictment.
Scott Holden, what do you make of Jane Mayer's contention, though, that another reason potentially that the DOJ was reluctant to go ahead with this was that they were concerned about the reaction of the CIA itself?
Well, are individuals inside the CIA? I mean, specifically what she said was that a senior figure in the White House had told her that there was a great deal of reticence to proceed with any criminal investigation and any action because it might prompt rogue action within the CIA that might undermine the White House, a new White House with little foreign policy experience in its first years in office. And I have to say, I spoke to a senior member of the Obama transition team who was responsible for legal policy issues, who said almost the same thing. This is very disturbing if it's true that that's part of the motivation, the concern about disloyalty or sabotage coming from within the CIA would have been a motivating factor. I find that very hard to see why this would drive the decision. But a decision to grant impunity would only encourage conduct like that.
Robert Grenier, as a former CIA counterterrorism.
Well, frankly, this would be outrageous because on the one hand, what CIA people, both currently serving and former, greatly objected to was in effect that the sense that this involves a certain form of double jeopardy. Now, as a legal issue, it's not double jeopardy, but the fact that these cases had been looked at thoroughly by prosecutors and had been closed by those prosecutors, to then be reopened by a new administration, made it seem as though this is going to be pursued indefinitely, essentially for political reasons. Now, so you can understand why that would be a problem in terms of morale within the organization. Exactly. So, and all that. But the problem was in making the decision to reopen the investigations in the first place. So if you didn't want to create dissension within the CIA, you wouldn't have made the decision to go forward with those investigations in the first place. What I think the professor is suggesting is there was sort of a wink and a nod to say, well, look, we've got to do this for political reasons. You understand, but don't worry, nobody's going to get prosecuted in the end. So again, I think we're back to a conspiracy theory here, and I just don't see any merit in it, quite frankly.
I'd say just the opposite, in fact. It's international conventions, the Convention Against Torture specifically, that mandates that the Justice Department conduct a complete criminal investigation anytime there is credible evidence introduced of torture having occurred. And it's completely clear that under the Bush administration, no such preliminary criminal investigation was conducted. That's what the Attorney General said. That's what the record clearly shows. So this idea that that something that was previously reviewed by the Justice Department was being reopened is just not true. I'm sorry.
And we mentioned,
I don't agree with that. So it was not a political decision. It was a decision to follow the guidance of the Convention Against Torture and U.S. law.
Given those conventions, though, what of international investigations now that it would appear that the U.S. has dropped any investigation?
There should be. I mean, with something as egregious as this, I mean, clearly there can be universal jurisdiction, and some other country can take, take authority over it. It's considered a war crime. And I just want to also clarify something because I think it's a confusion that a lot of people have, which is even if something is classified, which clearly a lot of the evidence is, that has nothing to do with whether it's admissible or not. You have the Classified Information Protection Act, which can have an entire trial that uses classified information. It's still admissible, it's just classified. And judges have security clearances. All of the habeas cases about Guantanamo, a lot of them involve classified information, so they're closed sessions.
That's absolutely right, and it's been exercised on numerous occasions.
Absolutely. I mean, court officers will tell you, we can prosecute
Professor
where
Horton, I mean,
classified information.
that was part of your argument there as to why the Attorney General might have thrown it out.
Yeah, I don't think that can be a reason.
Professor Horton?
Well, I think a decision has to be made by the prosecutors that they're going to go ahead and use the evidence. That's the question, and that's the limitation I was suggesting here. Because in many of these cases, yes, the fact that something is classified doesn't bar its being used, but the prosecution and the government will make a decision as to whether or not they wish to use it. And I think here there may very well have been a decision not to use it.
Well, one thing we have got from WikiLeaks, of course, is that the Obama administration has tried to lean on, for example, Spanish investigators as they look into prosecuting some of these crimes. I mean, do we have any indication that this isn't? I guess it's very difficult to get any indication of this. But I mean, do you think the Obama administration would be using all its means necessary to prevent international investigations from now on, though, Professor Horton?
Well, yeah, I think we should enumerate. There are actually pending investigations right now in Italy, in Spain, in Germany, in Poland, and Australia, all of which cover CIA operations, including black site operations, and what occurred there. We have WikiLeaks disclosures that show that were really extraordinary efforts by the U.S. government to shut down the investigations in Germany and Spain. And I think we know that they had some success in both countries, but not total success. But we know also in the Spanish investigations, the Justice Department was making representations there that the Spanish investigators should not continue to look at the matters they were investigating because of the pendency of John Dunham's investigation in the United States. And that now is gone. So I think the door is now clearly open, and there clearly is a green light for the other criminal investigations to proceed.
I just want to raise one last point, because we are running out of time now. I mean, President Obama said torture would no longer be permitted. However, he said that interrogations would be governed by the Army Field Manual. And there's a great deal of concern because, of course, because Appendix M of the Army Field Manual does appear to sanction psychological torture. Here's what the Center for Constitutional Rights, how they put it. Appendix M allows the use of techniques such as prolonged isolation, sleep deprivation, sensory deprivation, and inducing fear and humiliation of prisoners. These techniques, especially when used in combination as permitted by the AFM, constitute cruel, inhuman, and degrading treatment, and in some cases torture. These techniques have caused documented, long-lasting psychological and physical harm and were condemned by a bipartisan congressional report released last month, as well as by the Bush-appointed head of the military commissions at Guantanamo. Robert Grenier, how can we be confident that torture still isn't going on there under the Obama administration?
Well, this has been an issue that has plagued, I think, the entire government and everybody involved in the war on terror, if you will, right from the start, and it's a matter of definition. So
these questions still remain, though.
Right. Well, some people have taken it. Again, Senator McCain, who has personal history with torture and who was instrumental at a certain point during the Bush administration in making it very clear that he would not condone these activities, which he considered to fall under the rubric of torture. He was quite comfortable with the use of the Army Field Manual. And so apparently some others, this is news to me, but some others have taken a look at this and said, no, we think this goes too far. So at the end of the day, you need to figure out what the rules are, and then...
But isn't without any
saying that torture is a question of definition is sort of falling into the OLC memo trap, which, I mean, that memo has been repudiated.
So without this accountability,
I mean, torture is not a question of definition.
So do all these questions still remain, despite...
Absolutely, absolutely. And I can tell you from my organization is scientific and medically based, right? And so one of our big issues is Appendix M. I can tell you for a fact that, based on scientific and medical data, that the use of, in combination, use of techniques such as sleep deprivation, sensory deprivation, solitary confinement, rises to the level of torture because of the psychological and physiological consequences that it have, that equal the same consequences that might be used with torture that you would accept. or that you would call torture in sort of, you know, fingernails being pulled out and such.
Again,
so
I think
that is scientifically based.
which is fine. I don't have any quarrel with it. I'm just saying we need to agree what the rules are.
Right. Well, but without
Rather
Professor
than-
Horton, without accountability and oversight, apparently, I mean, how are those rules then going to be agreed upon? Or perhaps some would argue Professor Obama has moved on to, you know, extrajudicial killing, I suppose. So torture isn't maybe the main issue of this administration. I don't know. I mean, you know, that any male over the age of 16 is a militant and can be killed anywhere in the world.
Well, I think outside observers are free to question whether or not the U.S. is adhering to its obligation to ban, criminalize, and prosecute torture in view of these actions. I mean, it's not just this action, it's a series of others as well that show a growing attitude of impunity on the part of the U.S. Justice Department with respect to conduct that amounts to torture that involves U.S. government actors.
Professor Horton, I have to stop you there. We're out of time. Sadly, though. Professor Horton, thank you. Professor Husky, thank you. Robert Grenier, thank you. That's it from the team in Washington, D.C.